Thank you for listening to the Council of Institutional Investors, Voice of Corporate Governance. I'm Jeff Mahoney, General Counsel of CII. The purpose of these monthly episodes is to update CII members and the general public on significant developments in corporate governance, in capital markets regulation, and CII's related advocacy activities. This update covers a period from September 2nd to October 1st, 2025. The following is my top 10 list of events over that period. Number 10, on September 4th, the new regulatory agenda was published by the Office of Management and Budget. Regulatory agenda includes anticipated U.S. Securities and Exchange Commission actions on shareholder proposals, a project aimed at rationalizing disclosures, and updates to small entity definitions. The agenda indicates that the SEC plans to issue proposed rule amendments on shareholder proposal modernization in April of 2026. The agenda says the amendments would modernize the requirements of Exchange Act Rule 14A-8 to reduce compliance burdens for registrants and account for developments since the rule was last amended. The SEC anticipates issuing proposed rule amendments to rationalize disclosure practices to facilitate material disclosure by companies and shareholders' access to that information in April of 2026. Proposed rule amendments that would update the definition of small entity are expected to be released in October of 2025. Those amendments would increase the asset-based thresholds used in the definitions of small business and small organization for purposes of the Regulatory Flexibility Act, which requires federal agencies to consider the potential economic impact of the regulations on small businesses and to explore options for reducing any significant impact on those firms. The comment period for the agenda closes on October 22nd. The Council of Institutional Investors currently plans to submit a comment letter in response to the agenda. Number 9, in a September 19th speech at the Better Markets Academic Advisory Board's annual conference, Commissioner Carolyn Crenshaw of the U.S. Securities and Exchange Commission said, as calls for retail investor access to private markets accelerate, I am concerned that we are headed for a high-speed collision with Main Street retail investors left without airbags. In her comparison of driving on the Autobahn to investing in private markets, Commissioner Crenshaw expressed concerns that the line between public and private markets is being blurred. Commissioner Crenshaw said she's worried that the push for private market access is being done without regard to the risks and current performance of those markets, and that the regulatory oversight of private markets has not been right-sized given its significant expansion. Commissioner Crenshaw said concerns about lagging initial public offering numbers do not warrant a push for even more capital in private markets, but instead indicate a need to adequately adapt our regulatory regime to address the private markets as they have grown to exist today. Commissioner Crenshaw cited actions the SEC has taken to open private markets further and pointed to proposals to change the definition of accredited investor and qualified purchaser to increase retail investors' direct access to private markets. Commissioner Crenshaw stated that the current market conditions make me deeply skeptical of calls to democratize access to private markets and forsake the public-private divide without the addition of corresponding protections to retail investors. Commissioner Crenshaw explained that retail investors are likely to get access to only leftover private investment that more sophisticated investors have already turned down. Commissioner Crenshaw warned those will come with higher fees than traditional retail investment. All of this is to say retail investors' retirement savings will be used to prop up wobbly private markets purely to save private firms hungry for more capital and to benefit asset managers eager to collect the exorbitant fees. Commissioner Crenshaw pointed to risks in the private markets, including private credit's interconnectedness with banks and insurers and the concentration of private fund assets in only a few large managers. Commissioner Crenshaw concluded with the following caution: these risks, among others, warrant a watchful eye, and that's just the risks that private markets present before we introduce the added complexity of retail investor access. Number 8, on September 3rd, the NASDAQ proposed revised listing standards that are aimed at cracking down on small Chinese companies. Under the new standards, companies principally operating in China, including Hong Kong and Macau, must raise at least $25 million in an initial public offering to go public on NASDAQ. The NASDAQ said in an announcement that by applying this threshold, NASDAQ strengthens investor protections and enhances the liquidity profile of companies to reflect today's market environment. NASDAQ noted that when reviewing trading activity, it found emerging patterns associated with potential pump and dump schemes in U.S. cross-market trading environments. The Wall Street Journal reports that since August of 2022, nearly 70% of cases the exchange has referred to the U.S. Securities and Exchange Commission or the Financial Industry Regulatory Authority were related to trading in Chinese companies, despite the fact that such companies represent less than 10% of NASDAQ listings. In addition to boosting the minimum required for an IPO, the new listing standards include an accelerated process for suspending and delisting companies with a market value of listed securities below $5 million that no longer meet NASDAQ's listing standards, and a $15 million minimum market value of public float for future listings. The SEC must approve the new listing standards. Following approval by the SEC, the NASDAQ is proposing to give companies already in the initial listing process a period of 30 days to complete that process under the prior standards, and thereafter all new listings will have to meet the new requirements. Regarding the accelerated process for suspending and delisting companies, NASDAQ is proposing to implement the new requirements 60 days after SEC approval. The comment period for the proposal expires on October 10, 2025. CII currently plans to submit a comment letter in response to the proposed listing standards. Number 7. In a September 4th letter to the U.S. Securities and Exchange Commission, the Council of Institutional Investors expressed support for more stringent and expansive regulations on foreign private issuers, reflecting a broader view that quality disclosures by both domestic and foreign companies are beneficial to investors. Letter was sent in response to a request for comments in connection with an SEC July concept release on foreign private issuer eligibility. CII's letter says U.S. investors may not always be sufficiently protected given the accommodations and benefits enjoyed by foreign private issuers. Those accommodations may undercut what CII believes to be effective corporate governance due to at least two factors. One, insufficient disclosure and transparency generally, and two, insufficient reporting, including on a quarterly basis, on executive compensation, and on trades by foreign private issuer insiders. CII's letter says limited access to material information means that investors cannot fully assess the risks that they may be exposed to from investing in foreign private issuers. CII points out that Chinese variable interest entities in particular may pose a risk to U.S. investors. A recent CII publication entitled Behind the Veil: Risks of Chinese Companies in the VIE Structure indicates that these entities, typically incorporated in the Cayman Islands and subject to weak Cayman corporate law, are often fraught with complexity and risk for U.S. investors, including vulnerability to the Chinese government's pressures and management conflicts of interest. Also, the variable interest entity structure could be deemed to contravene Chinese laws that restrict foreign investment in strategically sensitive industries. Variable interest entities also operate using contractual arrangements rather than direct ownership, leaving foreign investors without the rights to residual profits or control over companies' management that they would otherwise enjoy through equity ownership. CII's letter urges the SEC to consider these risks when proposing a potential redefinition of what constitutes a foreign private issuer. Number 6. On September 18th, the Council of Institutional Investors, General Counsel, accepted an invitation to participate in a panel discussion at a meeting of the U.S. Securities and Exchange Commission's Investor Advisory Committee. The topic of the panel discussion was reconsidering the eligibility criteria and regulatory treatment of foreign private issuers. In the General Counsel's prepared remarks, he noted that a relevant question raised by the SEC's July concept release is how the SEC can change the foreign private issuer regime to reestablish the animating principle identified by SEC Commissioner Hester M. Peirce. Namely, that foreign private issuers' eligibility is appropriate only for those companies that are subject to meaningful regulation and disclosure obligations in their home jurisdictions. In reviewing the possible solutions to the SEC's question, the General Counsel commended his co-panelist, Paul Dudek, a partner at Latham and Watkins, for co-authoring one potential solution that the General Counsel indicated was worthy of the SEC's further consideration. That potential solution was described in a comment letter submitted by the Federal Regulation of Securities Committee of the Business Law section of the American Bar Association. The potential solution included 3 features. First, it retains the current definition of foreign private issuer. Second, creates a new definition that addresses the subset of foreign private issuers that are not subject to meaningful regulation and disclosure obligations in their home country jurisdictions. More specifically, the new definition would capture those foreign private issuers that have been identified by the SEC as having their equity securities traded almost exclusively in the U.S. capital markets. And the General Counsel noted that based on the SEC staff data contained in the July concept release, the subset of foreign private issuers that would be captured in this new definition is made up of more than 80% of foreign private issuers with headquarters in China and more than 80% of foreign private issuers incorporated in the Cayman Islands. Third, the proposal provides that those foreign private issuers that fall under the new definition would be required to comply with the following 3 additional regulatory disclosures. 1, the subset of foreign private issuers would be required to file financial statements on the new Form 7K, provided in a manner comparable to the information contained in a Form 10Q by domestic issuers, including, in the General Counsel's view, a requirement that the foreign private issuers file quarterly financial statements and apply the SEC definition of materiality rather than their local definition. 2, that the subset of foreign private issuers would be required to comply with the insider reporting provisions of Section 16A of the Securities and Exchange Act of 1934, including the filing of Form 4 reporting changes in ownership, and 3, that the subset of foreign private issuers would be required to file additional disclosures comparable to those provided by domestic issuers in response to items 1 to 6 of Form 8K, including, in the General Counsel's view, that those filings should be submitted within the same time period required for domestic issuers, which is generally 4 days from the triggering event. Number 5, on September 15th, the U.S. Securities and Exchange Commission granted a request from ExxonMobil for no-action relief for a retail voting program. Under the program, the company's retail shareholders could authorize ExxonMobil to vote their shares following its board's recommendations. Shareholders would be required to do this only once, and the company would have their authorizations for all future votes. Under the program, retail shareholders could authorize the company to vote the board recommendations for all matters considered at annual meetings or for all matters besides director elections and deals that require shareholder approval. The company will remind retail shareholders of their authorization each year and they will have the opportunity to cancel participation in the program. In addition, shareholders can override the board's recommendation on particular voting items by filling out a proxy card. ExxonMobil sought no action relief because technical regulations limit a company from soliciting proxies that extend beyond the next annual meeting. The SEC agreed with the company's argument that the annual communication with shareholders and opportunities to override or withdraw from the program constitute only an annual proxy solicitation. In its arguments to the SEC, ExxonMobil says that 40% of its shares are held by retail investors, but only 25% of those shares voted at its 2025 annual meeting. The company argues that retail investors have expressed frustration over the time commitment required to vote annually, have indicated through engagements that they are eager for a more accessible way to cast their votes, and have said they would welcome the ability to give standing instructions to vote in accordance with board recommendation. The SEC's approval of no action relief for the program has sparked debate, and some legal experts believe the SEC's decision to issue a no action letter in lieu of a rulemaking and a comment opportunity is vulnerable to legal challenge in federal court. In its press release and related communications about the program, ExxonMobil portrays its proposed pro-management voting program as a functional alternative to third-party voting guidelines such as those offered by As You Vote and other voting platforms. That portrayal was addressed in a September 30th letter to the staff of the SEC's Division of Corporation Finance from Daniel Fougere, President and Chief Counsel of As You Sow, and Josh Zinner, CEO of Interfaith Center for Corporate Responsibility. In the September 30th letter, Fougere and Zinner described the following 4 reasons why the ExxonMobil proposed pro-management voting program is distinct from the As You Vote voting guidelines. 1. The As You Vote voting guidelines are available to all investors and apply to all companies in which the share owner is invested, giving investors the ability to easily vote across the range of companies they own. 2. As You Vote does not solicit, hold, nor seek to continuously retain investor proxies as ExxonMobil's program does. 3. Significantly, As You Vote has no direct interest in the outcome of a company vote as ExxonMobil's management does. And 4, finally, As You Vote is one of many third-party voting guidelines found on voting platforms that make it easy for investors to find voting guidelines that align with their own investing goals, giving life to the concept of shareholder democracy. The Fougere and Zinner letter concludes by stating, quote, "We respectfully request that the Commission reconsider and rescind the no action relief granted to Exxon in its September 15, 2025 letter. Such rescission is necessary to preserve the integrity of the proxy rules, ensure compliance with the plain language of Rule 14A-4, and protect the effective decision-making rights of retail shareholders," unquote. Number 4. On September 17th, the U.S. Securities and Exchange Commission approved a controversial policy statement explaining that the Commission would no longer factor the presence of mandatory arbitration clauses in corporate governing documents when considering whether to accelerate companies' registrations for initial public offering. Such mandatory arbitration forces shareholders to pursue claims against companies for violations of federal securities laws in a private, confidential forum instead of in a court and without the option of filing a class action lawsuit. Instead, the SEC said it will focus on the adequacy of the registration statement's disclosures, including disclosure regarding the arbitration provision. The previous policy of refusing to accelerate registration statements with these clauses amounted to a Commission prohibition on mandatory arbitration provisions because companies were deterred from including them in their governing documents. The Council of Institutional Investors has long opposed such clauses in corporate governing documents. Its membership-approved policies addressing this issue state that companies should not attempt to bar shareholders from the courts through the introduction of forced arbitration clauses. CII has argued the fact that disputes that go to arbitration rather than the court system generally do not become part of the public record means that their deterrent effect may be lost. In a September 16th letter to SEC Chair Paul Atkins, Senators Elizabeth Warren of Massachusetts and Jack Reed of Rhode Island warned that if the reversal of the decades-old policy on mandatory arbitration were enacted, shareholders would be subject to a regime where the facts of a case are hidden behind closed doors and participants are subject to confidentiality obligations, bad actors are not accountable to the public, and there are no legal precedents to guide future conduct. SEC Commissioner Carolyn Crenshaw, the only commissioner who did not vote for the policy statement, blasted the move, saying that it deprives shareholders of fundamental rights, fundamental choices, and they fly in the face of market integrity, fairness, and efficiency. Mr. Crenshaw also took issue with the fact that the SEC adopted the policy statement without first issuing a proposed rulemaking and soliciting public comments. Commissioner Crenshaw asserted we could have engaged in rulemaking, we could have considered building in guardrails to protect investors and market integrity, and we could have actually addressed complex substantive questions about the nexus between our policy statement and state law and the fiduciary duties corporate managers owe to investors. A memo by the law firm BCLP points out that many investors are opposed to our mandatory arbitration clauses. Companies that adopt them may be targeted with shareholder proposals, vote no campaigns, or proxy contests. Additionally, notes BCLP, Glass Lewis may recommend voting against the governance chair or the entire committee when governance documents require arbitration of shareholder claims, and Institutional Shareholder Services is likely to take a similar position. Number 3, on September 9th, CII's fall conference included a plenary session entitled Depoliticizing Investment Decisions. Panelists discussed the increasing pressure on institutional investors from the federal and state governments to invest in or divest from certain industries and assets during a plenary session at CII moderated by Matt Jacobs, former General Counsel for CalPERS. Ann Sheehan, Senior Advisor at PJT Partners, explained, quote, "We have really seen the politicization of the investment process, which puts great stress on the fiduciaries, the trustees of these funds, in terms of making decisions that are really for their beneficiaries." Sheehan said, sometimes the divestment mandates passed by the state legislature contradict with the California Constitution, which requires state funds to diversify to the entire market of investment opportunities. She added, when the legislature asks you to defend your investment decisions, you discuss with them what the constitutional obligation is and the process that we have to go through in terms of our fiduciary duty. And most of the time they understand that, but at times they don't. Frank Partnoy, Adrian A. Cragen, professor of law at UC Berkeley School of Law, explained a new theory posing that fiduciaries should be thinking about their beneficiaries' welfare, not just their wealth. Partnoy also said that when confronted by state or federal mandates, fiduciaries should make their decisions whether to invest or divest based on the best information that they have at the time. Partnoy asserted decisions should not be adjudicated based on how things happen to turn out. Partnoy added, I think it's a mistake to look at your decisions with respect to these important political issues after the fact. Florida has had one of the most aggressive divestment protocols in the nation, noted Mike McCauley, Senior Officer of Investment Programs and Governance for the State Board of Administration of Florida. In 2007, the state legislature enacted its largest divestment mandate, which originally was focused on petrochemical and energy from the Middle East, but has since expanded significantly to total about $2 billion. McCauley explained that all of these divestments have actually helped boost the pension fund's financial performance, in contrast to Florida's divestment from tobacco, which cost the fund about $400 million. McCauley noted that in order to defy any divestment mandates, the fund has to experience losses in excess of 50 basis points at the total fund level. Number 2, on September 9th, CII's fall conference included a plenary session entitled Proxy Advisory Firms in the Crosshairs. In a discussion moderated by Konstantinos Zergakis, chair of the Best Practice Principles Oversight Committee, representatives from the proxy advisor firms debunked myths about how they operate and how their clients use their services. Sarah Wilson, CEO of Minerva Analytics, explained there are 52 markets around the world that people might be invested in, and the data's all over the place. We play a very important role making sure that investors have decision-useful data and information so that they can fulfill their fiduciary responsibilities. Wilson also said calls for more regulation of proxy advisors result from the fact that they have become a political football, an easy prey for vested interests to latch onto. Wilson said, instead of focusing on increasing regulations, efforts should be made to reform proxy plumbing to make it easier for shareholders to execute their ballots and have better relationships with companies. Wilson also asked why there are other actors in the proxy chain who are not regulated that have not drawn the attention of politicians. Nicole Garçon, Chief Legal Officer and Senior Vice President of Corporate Development at Glass Lewis, said her firm is not opposed to reasonable regulation as long as it comes from constructive dialogue. Garzon said, if it isn't a violation of the First Amendment or it doesn't require us to give away our research for free, we could work with something, but what we've seen in the past is just not workable at all. Garzon said she hopes the preliminary injunction that paused implementation of the Texas law putting onerous burdens on proxy advisors sends a signal to other states that it's a bad idea. Garzon warned that 50 copycat laws in states would be problematic, not only for Glass Lewis, but for its clients. Lorraine Kelly, head of governance solutions for ISS Stocks, said that requests for more regulation are not coming from proxy advisors' clients, but from the subjects of the services they are providing, the corporations. Kelly also noted that ISS's voting recommendations are aligned with management 90% of the time. Allison Badurka, head of product and research for Egan Jones Proxy Services, said that in addition to passing laws to regulate proxy advisors, states are exerting pressure on the firms through other means. Verdurka noted that multiple state attorney generals have sued proxy advisors, and some states have placed restrictions on their pension funds considering ESG issues when casting proxy votes. Verdurka said, so the question is what sort of regulation is needed to actually protect shareholders and to protect stakeholders, and what's being proposed in Texas is not doing that. And my number one most significant development in corporate governance capital markets regulation for the period from September 2nd to October 1st, 2025, occurred on September 8th at the Council of Institutional Investors Fall Conference in a plenary session entitled Law at Crossroads, Delaware's Legacy Meets Texas Ambition. In a discussion moderated by CII's General Counsel, founding director of the John L. Weinberg Center for Corporate Governance at the University of Delaware, Charles Elson, gave an overview of the history of Delaware state corporate law. Elson explained that Delaware became the premier state for companies to incorporate in because it was close to New York, where many companies were originally incorporated, but it had few businesses that could exercise influence over corporate law, and it had a small court that was not very active. Elson said that court, the Delaware Court of Chancery, over the years developed expertise in corporate law and applied it consistently to protect investors. Then in the 1990s, compensation controversies led to management no longer being viewed as the faithful fiduciaries they once were. As a result, the Delaware courts began to take a different tack, balancing shareholder prerogative and managerial prerogative. 2 years ago, a group generally representing controlling shareholders was upset about some of the rulings that came from Delaware's courts that they viewed as hostile to their interests. They suggested that if the state did not change its system to protect them, companies would reincorporate in other states. Elson said that this group was able to push through legislation that dramatically shifted the balance to the managerial side. Now, Elson predicts that corporate law may have to be federalized to create a uniform standard for the nation. Elson said Delaware provided that national standard, and it did it very well. John Skakun, a partner at Sidley Austin who represented a special committee of Tesla's board, argued that Tesla did not reincorporate from Delaware to Texas because its CEO, Elon Musk, was angry that the Delaware Chancery Court struck down his $56 billion pay package. Instead, Scahoon indicated that the special committee of the board made an independent decision to move to Texas. Scahoon also said that before the Delaware Chancery Court nullified Musk's compensation, other boards and directors he was advising had expressed concerns to him about the decisions coming out of Delaware. Scahoon also said, while most of the focus about reincorporations is centered around how they can lead to a loss of shareholder rights, including the right for small shareholders to file derivative lawsuits against companies and or their boards, attention should also be directed at the cost of these lawsuits. Scahoon said these costs are not only monetary, but also may result in distracted directors and executives who cannot think about how to drive the business and perform for investors. Scahoon said, there's a real question of whether or not people with very little economic interest, who are largely acting at the behest of plaintiff lawyers who have a huge economic interest, are really driving the bus in a way that shouldn't happen. After giving a detailed description of the Texas law placing onerous restrictions on institutional shareholder services in Glass Lewis and the arguments that the proxy advisors used in their case contesting the law, Ann Lipton, professor and Lawrence W. DeMuth chair at the University of Colorado Law School, blasted Texas for using its corporate law to fight a culture war. Lipton said provisions in the law were so poorly drafted that they do not indicate a serious approach to corporate law, but instead appear to be an expression of rage. Lipton warned that as a result, companies that incorporate in Texas are opening themselves up to serious risk. Lipton asked, what if you want to use the word sustainability in your marketing materials? Is Ken Paxton going to sue to dissolve your charter? Lipton responded to her own question, maybe, but I don't know, and no board does either. That completes my monthly update on significant developments in corporate governance and capital markets regulation. If you have any questions regarding any of the issues discussed, please feel free to email me at Jeff, that's Jeff, at CII.org. Until next time, I'm Jeff Mahoney. Thanks again for listening to The Voice of Corporate Governance.
Thank you for listening to this episode of The Voice of Corporate Governance, brought to you by the Council of Institutional Investors. The Voice of Corporate Governance is a free, non-sponsored podcast that highlights critical developments in corporate governance and other important issues affecting institutional investors. The views expressed by those interviewed on the podcast do not necessarily reflect the views of CII or its members. For more information on CII and its policies on corporate governance, please visit our website at www.cii.org.